May it please your lordships.
Yes.
My lords, I beg to mention item 6 in the hearing list.
Yes.
My lords, if this matter can be adjourned for a week. My lords, I have to travel out of station tonight. If we start today, it may not finish.
Who's the other side?
Lordship, I am for respondent 1, writ petition.
Mr. A. Zimomi, learned counsel for the appellant, seeks adjournment of hearing of this appeal for a week by expressing personal difficulty. Since the prayer is made with the consent of Mr. Apok Pogner, learned counsel for the respondent number 1, the same stands allowed. Let the matter be listed accordingly.
Much.
The prayer stands allowed. Yes.
For admission, item number 1.
Please, Your Lordships. Your Lordship, I am for the sole respondent, Your Lordship. I'm here to file my affidavit in opposition, so kindly allow me some time, Your Lordship.
What is the matter? Why are you challenging this judgment? It's covered.
Lordship, the petitioner is a ward charge employee, and he's not holding a sanction post. And we have the government, we have the policy for regularization, and he does not come within the regularization because he is not the senior most. He stands at serial number 9 at the time of his release from the service, Your Lordship.
But you have regularized the services of juniors to him.
No, Your Lordship, because those people comes within the zone, Your Lordship. Only after the regularization, after his release, Your Lordship, they were regularized, and some were regularized prior to his release from service.
So what is wrong with the judgment according to you?
Lordship, because he does not come within the jurisdiction, within the policy, so he cannot be regularized. And regularization can be made only as per the policy of the government, Your Lordship.
Why he doesn't come within the policy?
Because he does not stand at serial number 1 at the time of his release, and the persons who are before him are already released, and they are also not regularized, Lordship. If we see the seniority list.
No, but somebody works for 35 years and you don't want to give him pension now.
Lordship, so in that case, he has to make a case in order to get the pension.
Sorry?
He has to come within the policy in order to get the pension, and sympathy cannot be the ground, Your Lordship. That is our stand.
We would have disposed it of, but she's asking for time. You are
Yes,
lucky.
otherwise, Your Lordship, even if she filed a cross objection or so, nothing is going to improve. Whatever she stated in the writ petition will cover. Dispose
All right,
lagi.
you take down. We'll admit it. Appeal will admit it.
Okay, Lordship.
Heard Miss V. Shukre, is it? Learned additional AG,
Yes, Your Lordship.
State of Nagaland, appearing for the appellant. Perus the impugned judgment in order dated 14/4/2022. Also heard submissions of Miss
Vitere.
G.
Vitere.
G.
V.
Tare, and a counsel appearing for this sole respondent. After hearing the submissions of both the sides, we are of the view that this matter would require detailed hearing. Admit the appeal. Since the parties are already represented, no further notice is required to be sent in this case. Let the matter be listed for hearing after 4 weeks.
Much blood.
For orders, item number 2.
Let this also. Lordship, by order date 3/5/2023, the State Council was directed to file an affidavit placing in your record the inquiry report. Lordship, I was informed that the state government has already filed the affidavit.
Sorry? They have filed.
Yeah, already filed. Lordship.
This appeal is by the state or by the individual.
Keep up, keep up.
Next week.
Next portal.
So now the inquiry has been.
Lordship, in compliance with the direction passed by the single bench, the state respondent have conducted an inquiry. In the inquiry report has been already filed.
The inquiry report is against the private respondent.
Against the private respondent, exactly.
So then the consequential action, have you challenged the inquiry? Who is for the private respondent?
No, so far they have not challenged.
For the state. For the state.
Lordships, I'm for respond number 4.
See, the inquiry report is against your client. Have you challenged it?
Lordship, my prayer is the main council is still on the way, so kindly pass over the matter.
Counsel is still on?
It's still on the way.
We're still on the way.
Yes, yeah, Your Lordship.
Lordship,
When is he likely to reach?
Lordship, in that case, after the listed meter, after the listed
After the
meter,
listed matter. Your Lordship.
or I mean, we're allowed to continue since my writ petition has been dismissed.
Why has it been listed for orders today?
Lordship, for orders, on last occasion, the state government was directed to file the affidavit. Now they have come back.
State has not filed affidavit.
They have already filed.
They have already filed.
But, yes, Lordship.
The appeal has not been admitted.
Admitted, Lordship. Only. Admitted, Lordship. No, Lordship.
Appeal has been admitted.
But Lordship, since the parties are represented, it's a short meter. The meter can be taken up for disposal now.
Heard learned counsel for the parties on the request made by both the sides. This matter, no, you're right. It is brought to the notice of the court that counter affidavit on behalf of the state has not been filed.
Already
No,
filed.
my lord, already filed additional affidavit,
Has
my
been
lord.
filed. Therefore, this matter can be taken up for admission hearing. Since the appeal has already been admitted, list this case for admission hearing after 3 weeks.
Much obliged.
For orders, item number 3.
My lord,
May I please, your lordship, here I'm yet to receive instruction, my lord. So, kindly allow me 3 weeks time, my lord.
What instruction you want? This is an appeal.
Yes, my lord, but since whether the petitioner is entitled or not, I need that instruction, my lord.
So you are seeking adjournment.
Yes, my lord. Let the matter be listed after 3 weeks, my lord.
Appeal has already been admitted. You are not aware. It has been admitted.
Yes, my lord.
All right. You take down. Mr.
E.T. Home.
Also, learned government advocate.
Yes, my lord.
Submits this, that instructions are still awaited, and therefore this matter be posted again after 3 weeks. Mr.
IMT launcher. IMT launcher.
Launcher is present on behalf of the appellant. We find that this appeal has already been admitted. As such, register to list this case for hearing after 4 weeks. In the meantime, the learned government advocate in Nagaland may obtain instruction.
Much obliged.
Much obliged.
For hearing, item number 4.
Service is not complete in respond number 9, is it? In this matter? Which service report on respond number 9?
My lord.
Respondent number 9 is not yet served in your matter.
My lord,
Who is the respondent number 9?
AG.
There is no standing counsel for AG. Is there any CGC? Central Government Council.
My lord, I'm appearing for response number 1 to 8.
We have served copy upon
What about 9? Respondent number 9.
N Muzui, my lord.
Is any Central Government Council present here?
Yes, yes.
Who is there?
N Muzui.
No, is he in the court?
N Muzui. N Muzui. Yes. Appeared.
So, counsel, you don't have a standing counsel out here for accountant general?
We have
Who is he?
N Muzui in Joshua Sigi.
He's not here.
My lord, today N Muzui is not present.
Lordship.
Yes, Joshua.
I'm one of the standing councils, Lordship,
Of Accountant General?
Accountant General.
You're the standing counsel?
Yes, Lordship.
You can accept notice on behalf of respondent number 9.
Lord, this matter, I think.
Mozoi already received.
Oh, Mr. Mojui has already received.
He has received.
Yes, received.
There are two council. One is N. Mozoi and
Let this matter be listed again by showing the name of Mr. N. Mozi,
my lord.
Lordship.
and it counsel for the respondent number 9 in the court list.
Much obliged.
Much obliged.
It's a problem. Yes, please.
Item number 4.
Lordship, this is a challenge to the service rules.
Challenge to service rules.
Yes, Your
This
Lordship.
matter will take time.
Yes, will take some time, Your Lordship.
So will you be able to finish it, this bench? You know, it is a very short tenure bench.
Yes. I'll. It'll take some time, my
take
lord.
some time.
Yes, my lord.
Next available DB.
No problem.
Right? Take down. Heard Mr. T. Pawnee, learned counsel appearing for the appellant. Also heard Mr. A. Joe, learned additional AG.
My lord, no, I'm for the private respondents.
Actually-
5 to 16, my lord.
Respond numbers 5 to 16. Who is for Ms. T. Shukre? V. Shukre. Learned additional AG, Nagaland is present on behalf of the official respondents. On the request of learned counsel for the parties, let this matter be listed for hearing again in the next available division bench.
Much obliged.
For hearing, item number 5.
Your Lordship, here also the petitioner, he is a war charge Chokidar. And after serving, he was released from service, Your Lordship. Your Lordship, at page 39 is his release order. Page 39, he was
No,
released.
this is an appeal against judgment dated 23rd November 2021.
23/11, yes, November, yes. So Your
Where is
Lordship,
the judgment? Which page?
yes, the operative, the judgment starts from page 85. From page 85, and the relevant portion is at page 97. Page 97, Lordship, I may be allowed to read?
Yes, please.
Yes, second para. The case of the petitioner therefore can be considered under the OM 2004, where there is no qualifying years of service. I am also not in agreement with the submission of the learned counsel for the state respondent that the OM 2004 is no more applicable for reason expressed above. Having considered the facts presented in the matter, we are also reminded of the judgment passed by the Apex Court, wherein it has been observed that the state is a model employer and service condition of the employee should not be utilized in a manner that it resembles exploitation. It is observed by the Apex Court that board charge employees could not be continued for unlimited period of time. When services of the employees are utilized for continuous long period, the nature of service of work or temporary employees would be considered as regular employees, and they would be entitled to all benefits under the rules extendable to regular employees. When the employee, after having served for decades as a board charge employee and superannuated, his pensionary benefit could not be denied. The above being the principle applied in nature of such employment by the Apex Court, there can be no different view to express. The petitioner herein has put 26 years, 10 months, and 28 days of service and was superannuated on attaining 16 years of age. This court is of the view that the petitioner has established his rights to pensionary benefit. The state respondent, especially respondent number 4, shall take steps to regularize the service of the petitioner a day before his superannuation to allow pensionary benefit to the petitioner. The exercise should be completed within 2 months of the passing of this order. Repetition is also allowed and disposed accordingly. So, Your Lordship, the learned single judge has said that the petitioner has established his rights and his case for consideration for regularization can be made under the OM 2004. So, Lordship may come to the OM 2004. That
So
is,
is there a stay of this judgment?
Lordship.
Is there a stay order?
Yes, yes, there is a stay order. Yes, Lordship. Page 99 is the OM, the policy of the government, Lordship. This is the OM dated 22nd September 2004. There are a large number of work charge employees in various departments. Many of these employees have been serving continuously for many years. They have been representing to the government for regularization of the service. Some departments have been regularizing the service of work charge employee from time to time against available vacancies. However, no transparent and rational policy and criteria is discernible in the process of regularization of service of work charge employees. Therefore, in order to examine the issue of regularization of work charge employee in various departments, the state government set up a committee under the chairmanship of such and such. On the basis of the recommendation of the Committee for Regularization of Work Charge Employees in the state, the government hereby adopts the following policy and scheme for regularization of the service of work charge employees serving under various departments of the state government. 1. Each department having work charge employees should maintain a list of work charge employees in various categories in orders of the length of service. Number 2, regularization of work charge employees will be done against available regular vacancies. Number 3, 50% of all regular vacancies of similar nature arising in a year will be reserved for regularization of work charge employees, and the remaining 50% will be filled up as per normal rules of recruitment. 4. Work charge employees will have the right to be considered first for regularization against 50% of all future vacancies of similar nature in the department for which they possess the requisite qualification. Such regularization will be considered on the basis of seniority cum merit. So, Your Lordship, the OM says that it should be on the basis of the seniority cum merit. So, Your Lordship, if you see the seniority position, Your Lordship, that is at page 100 is the seniority list of various categories under the Executive Engineer Urban Development in the year 2018. Then the page 104, Lordship. This is the seniority list of Chokidar. 104, Chokidar. Lordship, the petitioner stand at serial number 3, Chokidar, Alemba.
Yes.
So, Your Lordship, at the time of passing of this judgment, the other two persons who are senior to the petitioner has not been regularized. So, Your Lordship, even the Supreme Court, the apex court, that is the judgment that is at page 107. This is the judgment dated 11/7/2022. I may be read a few lines, Lordship. Feeling aggrieved and dissatisfied with the impugned judgment and order dated 19/4/2021, passed by the High Court of Gauhati at Kohima in writ appeal such and such, by which the division bench of the High Court has dismissed the said appeal and has confirmed the judgment and order passed by the learned single judge, directing the appellant state to regularize the service of the deceased husband of the respondent from 1 day earlier to his death and thereafter to pay the family pension to the respondent. The state has preferred the present appeal. Then Your Lordship may come to page 111. This is the relevant page. Para 4. Having heard learned counsel for the state and considering the submission made on behalf of the state, and having gone through the judgment and order passed by the learned single judge confirmed by the division bench, we are of the firm opinion that the High Court has committed a grave error in directing the appellant to regularize the services of the deceased employee 1 day prior to his death. 4.1. It is required to be noted that the deceased employee died in the year 2005. During his lifetime, he never claimed any regularization. That the respondent herein, original writ petitioner, wife of the deceased employee, claimed the regularization after a period of 12 years from the death of the deceased employee. At the time of the death of the deceased employee, he was not entitled to regularization as he was much below in the list of the work charge employees whose services were to be regularized. Under the regularization policy, the services of the ward charge employees were required to be regularized as per the seniority and as and when the vacancy arises. The services of the other ward charge employees, even who were senior to the deceased employees, were regularized in the year 2009, that is after the death of the deceased employee. Despite the above, the High Court has directed the state to regularize the services of the deceased employee 1 day prior to his death, which otherwise his services were not required to be regularized as his turn had not come and he was much below in the seniority list. 4.2. Considering the aforesaid facts and circumstances, the interim judgment and order passed by the High Court is unsustainable and the same deserves to be quashed and set aside. And later it has been set quashed aside. So, Your Lordship, the service condition of the ward charge employees, they are governed by the Nagaland Ward Charge and Casual Employees Regulation Act 2001, Your Lordship. So in that regulation, the definition of the word charge is that they are not holding a sanctioned post. So, Your Lordship, here when the petitioner, he does not come within the zone purview of regularization of the government, the learned single judge ought not to have directed the state to regularize the service of the petitioner 1 day prior to his superannuation. Then, Your Lordship, in the cross-examination, cross-objection filed by the petitioner, in the cross-objection raised by the petitioner is relying on page 10. He is relying on the Central Civil Services Pension Rules.
Just 1 minute, Mr.
Yes,
Speaker,
go
just
ahead.
1 minute. So this the judgment passed in WPC 266/2021, as referred to in page 90. That is the judgment which was upheld by the division bench and set aside by the Supreme
Yes,
Court.
yes, by the Supreme Court, yes. Because in that case also the petitioner husband was a ward charge employee and his seniority stands much below than his senior, whereas the learned,
So
yes,
persons senior to the petitioner, they have not been regularized.
not regularized. They were regularized only in the year 2009.
Yes, who is for the, yes.
My lord, as my learned friend has pointed out, there may be scale, but I'm relying on the Central Civil Services Pension Rules 1972. What does it say? Your Lordship may turn to page 10 of my cross-objection,
Page 10 of your cross objection.
my lord.
State of Nagaland, they have adopted the central pension rules?
Yes, we have adopted, but Your Lordship, my learned friend has totally misconstrued the provisions of the Central Civil Service Rule. It is not applicable to the ward charge employee. It's clearly mentioned. Yes.
That is why I want to refer to that. I agree to my learner friend. Application. We need this application. The person petitioner is out as per the Rule 2. But after Rule 2 in 1972, Government of India has taken a decision and given the Government of India's order. What does it see? One, grant of pensionary benefits to temporary government servants retiring on superannuation on completion of 20 years. Now, that is 10 years, my lord.
No, but these rules are not applicable to casual workers.
My lord, that is why let me come to the order. In terms of Rule 2, a government servant, including civilian government servant in defense services, appointed substantively to a civil service, a post in a pensionable establishment is eligible for grant of pension DCRG.
You're
Then,
reading from
my
which
lord.
page? You're reading from which page?
Page 10 of the cross subsection. Cross subsection, page 10. This is CC's pension rules 1972. So, as per the Rule 2, only the person who was appointed in pensionable establishment are eligible for pension in DCRG. Then, a government servant who at the time of retirement from service does not hold a lien on a permanent pensionable post is not eligible for pension in DCRG, but is eligible for...
Mr. Counsel, please read that word substantially. The appointment has to be substantial.
My lord,
Against a
that
vacancy.
is why I'm coming to that. The Government of India's order is a government servant who at the time of retirement from service does not hold a lien on a permanent pensionable post is not eligible for pension in DCRG, but is eligible for terminal gratuity under Rule 1, Sub-Rule 1 of Rule 10 or Sub-Rule 1 of Rule 11 of the CC's Temporary Service Rules 1965. Then the decision is this. The order follows. The question of grant of pension to government servant who retire after long years of service without being confirmed in any post has been under the consideration of the government. The decision follows. It has been decided that a government servant who in his retirement from service on attaining the age of superannuation or on being declared to be permanently incapacitated for further government service by the appropriate medical authority after he has rendered temporary service of not less than 20 years, which is now 10 years, shall be brought within the purview of CC's Pension Rules 1972. That is the order of the Government of India. In the condition, holding a pensionable post in a substantive capacity shall be dispensed with in his case. So this is the decision of the Government of India. So it is not necessary that somebody have to be in a substantive post. So consequently, such a government servant will be eligible for the grant of superannuation, the present case. take come retirement gratuity and family pension in accordance with the provision of the aforesaid rules. That is 1972 rules. Pension rules. My learned friend is fairly submitting in that line that we Nagaland follow 1972 CC's pension rules.
What else? Yes, please complete your argument.
My lord, from a cross objection, I have quoted page 3. For up 2.3,
The notification by which CCS rules have been adopted, is it a part of the record?
Lordship,
my lord,
no.
it's a matter of fact.
Yes, it is an admitted
Yes,
fact that
yes.
we follow the CCS pension rule. But what my learned friend is relying is totally he is misconstruing everything, because the CCS pension talks about a civil post. The petitioner is not holding any civil post. Then he is relying on that the question of this pension to be given to a person who has served for a long time without being confirmed. So the confirmation is also regarding against that civil post. The petitioner is a work charge employee. He is governed by the Nagaland Work Charge and Casual Employees Regulation Act.
See, the point here is
Yes.
the decision of the Honorable Supreme Court,
Yes.
setting aside the court's order,
Yes.
is on the point of regularization.
Yes. Pointing of
Correct.
regularization. Yes.
But even whether he is regularized or not,
Yes.
the question can also be looked at in this manner, that having rendered more than 26 years of continuous service,
Yes.
after his retirement, is he not entitled to some pensionary benefit?
Lordship, suppose if he comes within the purview of the policy and he has been regularized, then he will be entitled for pension.
Policy is for regularization.
Yes.
But even without regularization, he is not entitled to
No, he
pension.
cannot be.
Why do you say so?
Because, Your Lordship, the Central Civil Service Rule does not cover them if he is not a regular employee, if he is not regularized. Your Lordship, it very clearly says that page 10, the CCS pension rule application, safe as otherwise provided in this rule shall apply to government servants, including civilian government servants in the defense services, appointed substantively to civil services imposed in connection with the affairs of the Union, which are born on pensionable establishment, but shall not apply to number B, person in casual and daily rated employee, the number H, person whose terms and conditions of service are regulated or under the provision of the Constitution or any other law for the time being in force. Then, Your Lordship, even the government orders also clearly stated that a government servant who, at the time of retirement from service, does not hold a lien on a permanent pensionable post is not eligible for pension. So, Your Lordship, the next answer, this one is regarding with the confirmation of a post. So, once a person, when he is appointed, he will be on probation. Yes.
Madam.
Yes.
What is being asked by this court is this.
Yes.
No doubt, as per Rule 2,
Yes.
he's not entitled to.
Yes.
He's also saying that I'm not entitled to. But I am entitled on the basis of the order, which has also been adopted by the state of Nagaland, wherein it says that a person having completed 10 years or 20 years of service
No.
in an unconfirmed post would also be entitled to pension.
Knowledge.
That is his submission.
That's why, Your Lordship, what is my submission is that he should be holding a post. He should be holding a post, and his post will be confirmed, Your Lordship. As Your Lordship knows that
No.
confirmation of
No,
post.
madam, what about this particular order? Kindly come to page 10 of his cross objection.
Yes.
This is an order.
Yes.
This is in fact an office memorandum. Down below at page 11, if you see
Yes.
GI number OM dated 38/10/82 dated so and so. Has the Nagaland government adopted these rules or this office memorandum or not?
We adopted only the,
If you have
so far as
adopted
I know,
this-
Your Lordship, so far as I know, we adopted the Central Civil Services Pension Rules 1972.
No.
Yes, but even if we adopted this also, Your Lordship, is clearly stated that it does not cover the person, because see, the question of grant of pension to government servant who retire after long year of service without being confirmed in any post has been under the consideration of the government. It has been decided that a government servant, so he is not a government servant, he is only
No,
a workers employee.
No, just further read it.
Yes. Who in his retirement from service on attaining the age of superannuation or on his being declared to be permanently incapacitated for further government service by the appropriate medical authority after he has rendered temporary service of not less than 20 years, now 10 years shall be brought within the purview of CCS Pension Rule 1972. So here, Your Lordship, my answer is that the petitioner is not a temporary employee. He is not a government employee. He is a work charge employee. And the definition of work charge employee is clearly stated in the Nagaland Work Charge and Casual Regulation Act, Your Lordship, where the petitioner is not holding a sanctioned post. When a person is not holding a sanctioned post, can there be a confirmation of the post, Your Lordship? So, Your Lordship, the CCS rules which the petitioner is relying on, it does not cover his case. And even the other two,
In your particular Nagaland, which FRSR, do you have a FRSR on your own or do you follow the FRSR of the central FRSR?
of the central FRSR, yes, Lordship,
Central FRSR defines what is a permanent post, what is a temporary post,
yes.
isn't it?
Lordship, then in that case, Your Lordship,
Have you looked into that?
Lordship,
If
I
we have
not,
adopted
yes.
the central FRSR, I think 230 or 231, I suppose. And 219, I suppose. Two definition clause.
My lord, FR 9, clause 30 is temporary post means a post carrying a definite rate of pay sanctioned for a limited time. So I was in the scale of pay from the day one. FR 9,
This writ petition was filed after he superannuated.
Yes,
Malo,
yes, yes.
malo.
After he
After that,
superannuated, and after he was superannuated, he only make a representation to the government. So, Your Lordship,
For regularization.
yes, he make a representation only after his retirement, Your Lordship. And the two persons who are senior to him, they are still in post, and they have not been regularized. So, Your Lordship, my contention is that he is not holding a post. And the definition of a post, Your Lordship, Your Lordship,
Yeah, just a minute. basis of severity the scheme is not on the check. Therefore, the criteria involved in the scheme we cannot include. We will get to that the seniors are living regulations. Third, question of regularization of the first thing is pension. Pension is a creature of the rules. There has to be rules which specifically provide for pension. And relying on the central specifically limit to this. One of the categories is schedule. Reason is pension is chargeable. Look, section cost, you need a head. That head is without that, it cannot be pension. But to take in the pension, there is some scheme, say compassionate pension, etc. This can be done. But those, that kind of scheme has to also Act, watches.
That is the Nagaland Code, Volume 6, page,
Page
page 110. The Nagaland Work Charge and Casual Employees Regulation Act. Then definition 2 clause D, that is the work charge employee. A work charge employee means an employee engaged without sanctioned post under a work charge establishment. Then even for the regularizations, Your Lordship, that is at 12. The scheme for absorption of service. The state government may draw up a scheme for absorption of service of work charge employee into regular service. So accordingly, we have brought the scheme, Your Lordship. So, Your Lordship, what my learned friend is relying on the 1972 CCS pension rule, but the application of the Central Civil Service pension rule clearly says that it does not apply to the person in casual and daily rated employees. So, what the government order that was mentioned down below, that is also does not cover the casual employee. It talks about only the confirmation of the person to the post. It talks about the confirmation of the person to that post. So, Your Lordship,
Yes, difficult.
My lord,
Sympathies are there, but very difficult.
my lord, I'm not under some sympathy, my lord. I may be allowed to take your lordship to my cross subjection, page 3. That with regard to cross exercise, both page of Supreme Court direction is clear without ambiguity. That is, it my page 72 running page. This is in the case of Jagjeet Singh, para 35. There are some employees who have not been regularized in spite of having rendered services for 30, 40 or more years, whereas they have been superannuated. As they have worked in the work charge establishment, not against any particular project, their services ought to have been regularized under the government instructions, and even as per the decision of this court in Umatili, this court in the said decision is laid down that in case services have been rendered for more than 10 years without the cover of the court's order as one-time measure, the services be regularized of such employees. In the facts of the case, those employees who have worked for 10 years or more should have been regularized. It would not be proper to recollect term for consideration of regularization as others have been regularized. We direct that their services be treated as a regular one. That is the Supreme Court. However, it is made clear that these shall not be entitled to claiming any dues of difference in wages. Had they been continued in the service regularly before attaining the age of superannuation, these shall be entitled to receive the pension as if ye have retired from the regular establishment, and the services rendered by them right from the day they entered the work charge establishment shall be counted as qualifying service for purpose of pension. That is the Supreme Court decision.
What is your cross appeal, cross objection about?
My lord, my cross objection is that they are
Cross objection, you are aggrieved by part of the judgment.
my lord, no.
Then why have you filed
I
cross appeal?
am part of the judgment is that my learned friend produced a scheme for regularization. I'm not on the scheme for regularization. I am for the pension. So I didn't place that as a ground. I based
See,
my
just 1 minute. We don't know what to say in this regard. It is correct that if a person spends long years of service, even as a casual employee, then he cannot be just obliterated. His entire tenure cannot be just obliterated. To that extent, there are decisions in the context of the rules in this state of Assam. There are judgments. There are decisions of division bench of the Guwahati High Court where even if they are not regularized, minimum wages were paid. Correct. Now, question of payment of pension arises out of some rule. It cannot be just given by the court. The court can interpret a rule, but there has to be rule. The problem here is there is already a set of rules framed by the government of Nagaland that is related to vouchers employees. That is a rule framed under proviso to Article 309. None of these judgments were delivered after considering the rule. That rule is also binding. The decisions you are referring to, these decisions were not rendered in the context of the rules framed by the state of Nagaland, governing the conditions and terms of the casual vouchers workers. Now, the services of casual and vouchers employees can be regularized, but it has to be done in terms of a scheme. That scheme has to receive the approval of the cabinet. And in implementing the scheme, if there is any infringement of rights, then the courts will look into it. You are not challenging the scheme. There is no complaint about the scheme. So they are saying, as per the scheme, your turn did not come. So therefore, they did not regularize. Your only prayer in the writ petition is to regularize. After you have retired, the question of regularization does not arise.
My lord, that is the reason.
Listen, this will help
Yes.
you. We can go in the chamber and write a judgment. But listen
Madam.
to this. It might help you. If not in this case, some other case. Your only prayer in the writ petition is to regularize the service, which prayer cannot be granted under the law. Question doesn't arise. Your client has retired before the application was submitted. After attaining his age of retirement, no question of regularization. And that too when there is a scheme in place which is not under challenge. Scheme says in order of seniority come merit, and your turn has not come. That is what the state stands.
My lord, that is what I objected in my petition. You are saying that I have not served 26 years, 11 months, and 52 days.
Mr. MT, Lungchar, only one thing, what
Madam.
has been, you see, in your writ petition, your prayer was for regularization.
My lord.
The fact as regards bringing into account the CCS pension rules as well as the office memorandum, is it for the first time you have brought it in the writ appeal?
No,
No,
in
in
my
the-
writ petition,
in
that
the writ petition
writ
also he
petition
has stated
was
once-
this specifically.
But
My
he
lord.
did not pray on that.
But that was not considered
My lord.
because the judgment.
My lord,
does not
my
mention
learned
on
friend produced that scheme. So the honorable single judge have given that under that scheme is to be regularized. Whereas my petition from the D1 is page 26 of the appeal memo. Exactly is that one, page 26.
Yes, sir.
Is it in the context of this act? Which has to have the sanction of governor, finance, etc. This is not a post. It's with this plan.
Page 26, my lord. The question of grant of pension to government servant.
These are not appointments against any post. Where is the post? I'm asking you to show me now. Post, what are the meanings? Post, the create way. What's just as a post creating? This is usually not sanction post. All these are on post. These people are not on post. There is no sanction post. Please make it clear. How can a chair be any of this? These are rules under government.
My lord, my submission is that
This reason cannot
that
those are all posts. What happens is just a minute. Just a minute. Charge the interim checker. Salary, pension, gratuity, charge security checker. So when there is a post, that post carries along with all these sections, budgetary sections. Here the included in the charge gets the sanction of the government. Then it is notified. Yes. So the person he holds a post, so he is regularly approved. He goes on to serve in return, but the pension so income progress. Now, for some reason, person works in the temporary post without being confirmed, he retires. Confirmation was not done because of some problem with the department. In these contexts, these notifications are issued so that he does not suffer any prejudice. But the money is already loaded in the post for salary as well as pension. But when you are engaged with the careful labor, it is not done against any post. There is no budgetary sanction. It comes as office head expenditure of the defense department. I mean, I'm engaged on a daily basis. Daily basis. Then level 80. Suddenly to say that now you regulate them, this kind of thing, then this kind. To say that we pay pension, you know, beyond the mandate of the government. That's the problem. You can't do it. You set aside. No, it will be okay. That's what I'm saying. It's a tough case for them. Funny.
my lord,
Yes, please conclude.
this honorable court itself has decided that is impulse bench. The question of entitlement of pension, page 4 of my petition, which is 10 years, has been clearly settled by division bench of this court. That is 1997-2 GLD 207, State of Manipur in order versus Ipopal Singh, State of Manipur in Angolwat. Service contract appointment, employee continuing in contract service for nearly 3 decades in being superannuated were denied pensionary benefits, my lord.
What is this? Your act speaks about wage to the casual employees and then talks about
Yes.
scale.
Because we have casual employee as well as the ward charge employees. So the wages that is fixed by the wage. Yes, lordship. It is fixed by the commission.
No,
Your Lordship,
no,
of the ward charge.
wage and scale are two different things.
Yes, yes,
You have
that is
used this
different
term interchangeably in the rules.
Yes, because Your Lordship,
Act.
at section 6, it clearly mentioned as provided, because prior to the enactment of this act, some ward charge employees, they were on scale of pay. So it provided that the wage of the ward charge employees who was paid a scale of pay at the commencement of this act and who is reappointed under sub 2 of section 5 of shall be not less than the last pay as may be determined at the time of prescribing fixed wage, Your Lordship. Because before the enactment of the act, somewhere on
We are not happy with the judgment, but this
Yes.
matter would require more research.
My lord,
No, Your Lordship, is
that is
very,
what
Your
exactly.
Lordship, it's very clear when the CCS pension rules, the application of CCS pension rule does not apply to the petitioner, who is a ward charge employee. Where is the question of the government order? The central government order talks about the confirmation of the post, Your Lordship. Because the application clearly says that it does not cover the ward charge employee, the casual employee. Then the government notification, it talks about the confirmation of the person to the substantive post, Your Lordship. Your Lordship knows that when a person is appointed, he will be on probation. Then after he will be, his service will be confirmed. So it says that a person uh, talks about the delay of confirmation of his service. It does not talk about the ward charge employee, Your Lordship. And then, Your Lordship, in that case, the definition of the meaning of a post, Your Lordship, that is mentioned by the Supreme Court, it clearly says that the post exists apart from the holder of a post. So when the casual employee, Your Lordship, every employee is an a post, but all employments are not posts. It's what the Supreme Court stated, Your Lordship.
You forget everything.
Yes.
There you are correct technically.
Yes.
Technically, you have a good case.
Mm.
But how do you justify this? The people working for 26, 30 years, they will get nothing after they retire
Your Lordship,
just because there is nothing in the rules.
My lord, FR 56 clearly talks about the work charge establishment. FR has already taken cognizance of the work charge. FR 56. This has been applied to me. Retirement. Except as otherwise provided in this role, every government servant shall retire from service at afternoon of the last day of the month in which he attains the age of 58 years. B, a workman who is governed by these rules shall retire from service on the afternoon of the last day of the month in which he attained 60 years. This has been applied fully to me. Then, what does the notice? In this clause, a workman means highly skilled, skilled, semi-skilled, unskilled artisan employed on a monthly rate of pay. I was paid in monthly rate in an industrial or work charge establishment. So I was in the work charge establishment. If our 56 is clear. So accordingly, I'm attaining 60 years. I have been superannuated. Only superannuation will be applied, but not the work charge.
Lordship, I may be allowed to rely on one Supreme Court judgment, Your Lordship. It's 2021 ACC Online AC 899, Union of India and others versus Ilmo Devi and another, Your Lordship. Lordship may come to paragraph 25.
Yes.
The observation made in paragraph 9 are on surprise and conjecture. Even the observation made that they have worked continuously and for the whole day are also without any basis and for which there is no supporting evidence. In any case, the fact remains that the respondents served as part-time employees and were contingent paid staff. As observed above, there are no sanctioned posts in the post office in which the respondents were working. Therefore, the direction issued by the High Court in the impugned judgment and order are not permissible in the judicial review under Article 226 of the Constitution. The High Court cannot, in exercise of the power under Article 226, issue amendments to direct the department to sanction and create the post. The High Court, in exercise of the powers under Article 226 of the Constitution, also cannot direct the government or the department to formulate a particular regularization policy. Framing of any scheme is no function of the court and is the sole prerogative of the government. Even the creation and or sanction of the post is also the sole prerogative of the government, and the High Court, in exercise of the power under Article 226 of the Constitution, cannot issue mandamus and or direct to create a sanction post. Then 26. Even the regularization policy to regularize the service of the employees working on temporary status and or casual laborers is a policy decision, and in judicial review, the court cannot issue mandamus and or issue mandatory direction to do so. Then, Your Lordship, para 27, in the case of Dayal Lal Supra, in paragraph, it is observed and held that we may at the outset refer to the following well-settled principles relating to regularization and parity in pay relevant in the context of this appeal. 1. The High Court, in exercise power under Article 226 of the Constitution, will not issue direction for regularization, absorption, or permanent continuance unless the employees claiming regularization had been appointed in pursuance of a regular recruitment in accordance with relevant rules in an open competitive process against sanctioned vacant posts. The equality clause contained in Article 14 and 16 should be scrupulously followed, and court should not issue a direction for regularization of services of an employee which would be violative of the constitutional scheme. Once something that is irregular for one of compliance with one of the elements in the process of selection, which does not go to the roots of the process, can be regularized. Backdoor entries, employment contrary to the constitutional scheme, or appointment of ineligible candidate cannot be regularized. Number 2, mere continuation of service by a temporary or an ad hoc or daily wage employees under cover of some interim orders of the court would not cover upon him any right to be absorbed into service, as such service would be litigious employment. Even temporary ad hoc or daily wage service for a long number of years left alone service for 1 or 2 years will not entitle such employees to claim regularization if he is not working against a sanctioned post. Sympathy and sentiment cannot be drawn for passing any order of regularization in absence of a legal right. Then your lordship may come to para 29. Applying the law laid down by this court in the aforesaid decision, The direction issued by the High Court in the impugned judgment and order, more particularly direction in paragraph such and such, are unsustainable and beyond the power of judicial review of the High Court in exercise of the power under Article 226 of the Constitution. Even otherwise, it is required to be noted that in the present case, the Union of India Department subsequently came out with a regularization policy dated such and such, which is absolutely in consonance with the law laid down by this court in the case of Uma Divi Supra, which does not apply to the part-time workers who do not work on the sanctioned post. As per the settled proposition uh, of law, the regularization can be only as per the regularization policy declared by the state government, and nobody can claim the regularization as a matter of right dehors the regularization policy. Therefore, in absence of any sanction posed and considering the regular fact the respondent was serving as a contingent paid part-time safari, the fact that even otherwise, they were not entitled for the benefit of regularization under the regularization policy. So, Your Lordship, when the petitioner do not have an established rights, the learned single judge ought not to have direct the state respondent contrary to the act as well as the office OM, the scheme. So, Your Lordship, my prayer is that the judgment may be question set aside and the repetition may be dismissed. That's my prayer, Your Lordship.
If my learned friend has completed, my lord, this honorable court, in my cross objection, it page 13. Two casual
You're Mr.
empty long term.
Mr. Intilonkar, what is your submission? Can you make it a very precise one? Because you have already taken us through the central CCS rules, etc. You have made your submission. So can you sum it up what your submission is?
My lord,
What do you want to say?
my lord, what I want to say is that this honorable court, when this Gauhati High Court was covering all the 7 states, page 13, this is state of Manipur versus Ipupal. These 2 gentlemen, they were appointed as casual artists. Then this honorable court, by a division bench, page 13,
Page 30 of
cross objection.
yes.
Service law, contract appointment employees continuing on contract service for nearly 3 decades in unpaying supper unweighted were denied pensionary benefits. This is a division bench. Health state being a model employer are not permitted to use method of exploitation against the worst section of people. Direction given to grant pensionary benefit to such similarly situated, not only the person who are before this court, similarly situated employee who have served more than 10 years of service on contract. We unequivocally of the view that the term contract appointment must be terminable at some stage of care service. But if contract appointment continued uninterrupted till the age of superannuation is happened, in the case it had, the character of the contract appointment automatically changes. And the
Okay, what else? Which is the next decision?
I have extracted in the book list for the respondent, book list, file on 2/11/2022. Book list for the respondent. My lord, it'll be before the lordship. Book list 1997 to GLD 209. Division bench, before we part with the record, we make it clear that this judgment of ours will be applicable to all the artists working under the department of such and such, who has served for more than 10 years of service on contract as an duty, so that unnecessary litigation are thwarted. We see this because of the high litigation costs in this country. Many common people may not afford to approach this court because of economic disparity, despite of having genuine grievance. 10 years, there is no argument to that. To qualify for pension, it is 10 years. So, my lord, what I'm submitting is that a division bench is way back in 1997 settled this issue. Who have worked for 10 years in above should be given pension.
Which is the last judgment you read? Last one, just now you read?
That is Ipo Hal Singh. I've submitted my book list for the respondent.
Which is your judgment?
That will be in the, I have furnished along with the photocopy of the judgment itself.
All right.
So,
You have the judgment.
my lord, if your lordship,
Can you get this citation, that one?
this is included in my cross objection also. Because this being the position as of today, since 1997, division bench,
All right, please don't repeat. You have made your submission.
my lord.
Yes. Anything else? Any new point, anything?
My lord, I've submitted on the Prem Singh, Chakchi Singh. So it is pensionable. Rule is clear. My learned friend is not denying to that. So on that basis, the appeal should go. That's my submission, my lord.
All right. Para did you say? This one, director did this. Para 9 or 115.
I'll see if I do. My lord, Supreme Court has given one judgment in the same line. People who have worked for so many days.
No, we agree. It's a human
Yes.
problem. There's no doubt about it.
So Supreme Court is very clear on that.
But we'll have to go by the law. That's the problem.
Yes. My lord, the law is that which will follow. Pension rules, pension rules, pension rules will follow. It is the pension rules. I'm not on the work charge in casual regularization. That's not the issue.
If
Unless-
the people
No.
who are in service
Lordship,
or who are still working as casual workers, watchers workers,
Yes.
they come before the court asserting a right that
My lord,
then the matter would be very
this is
different.
high.
Yeah, because we have, your lordship, thousands and thousands of work charge and casual employees. So by this OEM, we are banning the appointment of the engagement of the work charge
So you will
employees, your
give-
lordship.
Out of 100, you will give 5.
Yes.
Remaining 95 will come to court. How is it a solution?
But your lordship, see, in order to approach the court,
lucky that
there has
nobody
to be a right, your
Nobody
lordship.
has challenged that till today.
Yes, there has
Nobody
to
has
be a
challenged the
right.
scheme till today.
The petitioner has to establish a right, and before the petitioner is regularized, where is the question of pension?
We're not happy with the way
Yes.
state is dealing with these people. They are vulnerable people. Somehow they got into as watchers, workers. You have made them work for so long. They must go back with something when they retire. It is just on a technical ground that we are not going into these things. If anybody challenges this scheme, things could be very different.
Lordship.
All right, we'll
Much obliged.
dictate the judgment in the chamber.
Lordship.
Both of you have tried, but we'll have to go by the law.
My lord, law is clear about the pension
all right,
rules.
don't start
Yes,
asking.
no.
All right, so we'll
In
after 5 10 minutes,
1990
Mention item number 6.
Item number
Here,
6.
yes, Lordship. The leading counsel has some difficulties today. And since Lordship, this is an analogous matter, I, along with the consent of other councils,
These
let
are
the
all, item 3 to
Item 3 to 9, madam.
3 to
3 to 9 are all serious matters.
Yes, madam. All
yes, Lordship.
So what do you say, Mrs. Imam? He's seeking adjournment.
Yes, my lord. Some of the councils are not here, madam. And if some orders are passed, maybe adverse or
Okay, how much, how long?
okay.
Lordship, if it can come up on 24th of July.
24th of July.
That's fine because some of the lawyers are from out of station.
All right. You write, Miss, your Miss
Kate Secretary.
Kate Crew, learned counsel appearing for the petitioners in
In
item 6.
6,
Give the
yes.
case number. Huh? Submits that outstation counsel is appearing in this bunch of writ petitions and therefore admission hearing of these matters be adjourned and these cases be fixed again on 24th of July
July, yes.
2023. The prayer is not opposed by Mr. A. Zimomi, learned counsel for the private respondents, as well as the learned government advocate Assam appearing for the state. In view of the above, admission hearing of these matters stand adjourned till 24th of July 2023. List these cases accordingly.
Much obliged.
3 to
May I
9.
please, Your Lordship?
Yes.
Lordship, may I please to mention hearing item number 14 and 15.
14 and 15. What do you want?
Your
For the
Lordship,
government?
I'm for the government, Your Lordship. It's a consensus prayer, Your Lordship. So let the matter
With the
come up after.
consent of the opposite party. Miss, your name please?
Livika, Your Lordship.
Ms. Livika, learned government advocate Nagaland, prays for adjournment of the hearing of these cases for 4 weeks.
No, Your Lordship, 2 weeks.
For 2 weeks. Full stop. Prayer allowed. List the matters accordingly. Yes.
Much obliged, Your Lordship.
Obliged, Lordship.
Yes.
May I please, Your Lordship? Your Lordship, I beg to mention item number 2 on behalf of my senior.
Item number?
Item number 2, for respondent number 5, on behalf of my senior, Mr. Yangarwati, CGC, we have already filed our affidavit in opposition and sent it for necessary vetting. We are yet to receive it, so kindly give us 1 week time to file the same.
Yes. You are for the petitioner?
Yes, Lordship.
Miss, your name please?
Asikire,
Is so-and-so learned counsel appearing for the respondent number 5.
on
Submit-
behalf of
On
Yangarwati.
behalf of Mr. Yangarwati, learned counsel for respondent number 5, submits that counter affidavit has been prepared and the same has been sent for vetting.
Yes,
Therefore, a week's time has been prayed for bringing the counter affidavit on record. First of the learned counsel for the writ petitioner is present and does not have any objection if the prayer is allowed. In view of the above, let this matter be listed again after 2 weeks or immediately after the counter affidavit on behalf of respondent number 5 is brought on record. Yes.
obliged.
Obliged, Lordship.
Yes.
May I please, Lordship? Lordship, I beg to mention hearing item number 13, 11.
11, 12, and
11,
13.
12, and 13. Lordship, if this matter may be listed after 2 weeks
You are appearing for whom?
for the petitioner, Lordship.
For the state.
No objection.
No objection, Your Lordship, because there's a private respondent involved here, Your Lordship, and
She's not present.
she's not, yes, Your Lordship.
All right, Mr. Your name, please.
Lakne Pom, Lordship.
Mr. So-and-so learned counsel appearing for the writ petitioner in this batch of petitions prays for adjournment of the hearing of these matters for 2 weeks.
Lordship.
The prayer is not opposed by Mr.
And Angami, Your Lordship.
N. Angami, learned government advocate Nagaland, appearing for the official respondents. First up, the name of the learned counsel for the private respondent is shown in the cause list,
Yes, yes.
but the private respondent is not present before the court today. Be that as it may, let these matters be listed for hearing again after 3 weeks.
Deeply obliged, my lord.
Yes. So the list is over? Oh, one matter is there. Yes.
For motion, item number 1.
Yes.
May it please, Your Lordship. My lord, the NIDC is a government of Nagaland undertaking. So respondent number 3,
Where is the gradation list?
the seniority list, my lord?
Gradation list? Seniority list?
Yes, my lord. That is
That's
that-
called gradation list also.
Yes,
Page number?
page 116, my lord. 116 is
Page 116.
the covering letter, Your Lordship, dated 21/4/23, 116. And page 117 is the position of the petitioner and the respondent.
So there is a private respondent here, right?
Yes, my lord, there's a private
And
respondent.
you are appearing for whom?
For state respondent number 1, lordship.
1 and 2 also, my lord, because.
1 and 2.
Yes.
Lordship, without instruction, I'll appear.
All right, we'll,
Your Lordship, if I may, the managing director of the NIDC now is the same respondent number 1.
That may
That
be
is
the
why.
case, lordship, but let my instruction comes from respondent number 2.
In fact, the respondent number 1 is both the chairman cum managing director of the NIDC now, plus the commissioner secretary of the Department of Industries and Commerce.
all right. Take down hard Mr. A. Zamami, learned counsel appearing for the writ petitioner. Aggrieved by the seniority list of general managers in
Yes.
NIDC,
Yes.
notified by circular dated 21/4/2023, the instant writ petition has been filed. Inter alia contending that the respondent number 3, who is junior to the petitioner in service, has been shown above her in the seniority list. Full stop. In support of his argument, Mr. Zimami has taken the court through the documents annexed to the writ petition. Full stop. After going through the same, this court is of the opinion that this matter would require deeper examination. Stop. Issue notice of motion returnable in 4 weeks. Since Mr.
Kiangami, lordship.
So-and-so learned standing counsel, NIDC, is it your standing counsel? NIDC?
State Council, my lord.
State council, lordship.
Learned State Council has appeared and accepted notice on behalf of respondent number 1.
Lordship.
No formal notice is required to be sent to the said respondent. However, extra copy of the writ petition be furnished to Mr. So-and-so within a week from today. The petitioner to take steps for service of notice upon respondent numbers 2 and 3 by registered post with AD within a week from today. Heard on the prayer of interim relief, having regard to the facts and circumstances of this case, as an ad interim measure, it is hereby provided that the respondents shall not act on the basis of office circular dated 21/4/2023, bracket annexure 29, for further promotion in the
Well,
department.
Much obliged. My lord, in the petition, in the list of dates, there's a wrong entry. May I be permitted to correct that, my lord, in the dates? And in the paragraph also, one spelling mistake is there.
Those will be amendment. You ignore it for now, we'll see.
My lord.
Because you can't override things, that's not permissible. Let it be, we'll see. These
Very
are
well.
not material.
Not material, my lord, just wrong dates.
Yes, next matter.
For admission, item number 10.
Petitioners,
Lordship.
none
I'm-
appears for the petitioner on call. The petitioner's counsel was absent even on the last date, that is 29/5/2023, when this matter was listed before this court. Mr.
Vijimomi.
So-and-so, V. Jimami, learned government advocate Nagaland, is present on behalf of the state. Since the petitioner's counsel is absent, so as to give them one last opportunity to
Lordship.
appear and argue the matter, this writ petition stands adjourned for 4 weeks.
Lord.
All right,
Lord.
that's all.